the court improperly permitted the state to introduce evidence of Varekin, if that's pronounced correctly, his prior inconsistent statement where he spoke of the defendant's statement to him about how he killed Foley, I believe his name, of the victim, and pointing out that this is the event within the meaning of the statute of which Varekin had no personal knowledge, so that the situation was similar to that in Simpson, in which the defendant, the witness, I believe Franklin was the witness in that case, spoke about how Simpson told him how he had beaten the victim to death with a baseball bat, but Franklin wasn't there either. He had no personal knowledge of that event other than what the defendant told him. The Simpson case, Simpson being the defendant, the Supreme Court said that was a violation of the statute, and that's your claim in this case as well?
Yes, that is precisely the claim in this case, is that what the witness has to have personal knowledge of is the underlying events which he heard, not the occurrence of the conversation. As you may be aware, this court in Adamson found similarly regarding issues of personal knowledge, but also the facts that here, I mean, there's two bases in which Mr. Varekin's statements that he didn't have personal knowledge are not available. That one, but also the fact that he never specifically provided any affirmative damaging testimony in his responses. He simply responded consistently throughout his testimony that he did not recall the statements that he made to police.
Well, I have a question about it, though. Here's my question. At least some, I believe two specific instances of the statements made by the witness Varekin did not refer to a crime that has been committed. Instead, it referred to how, excuse me, the defendant, the night before Foley was murdered, was speaking with Varekin, according to one of these statements, about how he intended to commit the murder. This phrase about he was going to go duck hunting the next day, which apparently is supposed to be some reference to I'm going to kill some guy. You recall that?
I do recall that, Your Honor.
Okay. Well, and there's another one where one of these statements that was admitted in which the Varekin was talking about how the defendant was discussing with him how Foley should be killed and talking about whether Varekin, the defendant was asking Varekin, would he be the guy to do that? Recall that?
Yes, Your Honor.
So my question is, to what extent does it make a difference, keeping Simpson in mind, that Simpson, and I think all the cases cited in Simpson, deal with past crimes, that is, crimes that have already occurred, whereas, at least for these two statements I just mentioned, there were no past crimes. That is, and to be more specific, why wouldn't, under 115-10.1, the statement of the defendant, to Varekin about how he intends to kill Foley, why wouldn't that be admissible? Why wouldn't that be the event? There's no other event to which that statement could recur, is there?
There isn't any other event under which that occur. And while Varekin would not have personal knowledge of the future actions, and he wouldn't know whether or not those future actions were actually committed since he wasn't there for the event, they are outside of his personal knowledge. However, They're not similar to a recounting of the murder as the 3 points mentioned in our beliefs that were specifically should have been excluded. And the key critical difference mentioned in the briefs is that while the statements of what was going to happen or what had not happened before were circumstantial evidence, the statements of what had happened and precisely how the shooting had happened and why it happened were direct evidence of Mr. Scott's participation in the shooting. So qualitatively, we're talking about vastly different kinds of evidence.
Well, yes, and to be clear, the state introduced multiple excerpts labeling it 155A through M or whatever, I think, or O even, which were various excerpts of the same interview, but they used it for purposes of highlighting different aspects. So I understand your point that most of these excerpts dealt with past criminal behavior, as in Simpson, where the defendant is talking about prior crimes he has committed. But I just want to see if the analysis in Simpson about past crimes in the event that the witness had no personal knowledge of applies when we're talking about future behavior. It seems to me that this is different.
It is different in the fact that it was not something that had already occurred, but the fact of his underlying, if we're looking to the overhearer's knowledge of the actual, whether that occurred, the certainty, the reliability of these things, then it's no more reliable than a past statement.
Well, let me be more clear. In other words, let's assume that this wasn't a case where Verrecken was confronted with a prior inconsistent statement, but he took the witness stand. And he said, oh, yes, the defendant talked to me on particularly the day before Foley was killed about how he intended to kill him. That would be admissible, would it not?
That would be a statement of intent. That would be an exception to the hearsay requirement. Yes, Your Honor, I believe so.
It would be what? I couldn't hear you, sir.
It would be an exception to the hearsay requirement as a statement of intent. Yes.
Right. Well, it's a statement of a party opponent.
Yes. Similar.
That's by the defendant's own statement. So that's admissible, right?
Yes.
Okay. So in other words, let's assume that only these statements were admitted. This would not be a violation of the statute, would it? Statements about future behavior?
It would not be a violation of the statute, no, if he testified under it.
By the way, one other thing that I was wondering about. The record shows just before the defendant or the state rests, there was a discussion about who the defense would be calling to testify. And defense attorney said, I'm going to call one witness. And it's going to be the grandmother. But before that happened, excuse me, the parties stipulated to the prior felony conviction of the defendant for residential burglary to the jury. And the judge read that. And then a few minutes later, the judge asked the defendant, are you going to testify? No. And the judge explains his rights about all of this, and he never testifies. I'm just wondering what's going on here. It seems to me, I've had a lot of experience with felony trials, both as a trial judge and on the appellate court. I've never before seen an instance where the state was offering to prove impeachment by a prior conviction until after the defendant has testified. But in this case, he never did. So what's the stipulation to his prior conviction all about? And unless I missed it, I don't think you raised that in your brief, counsel.
You're correct, Your Honor. We did not raise an issue regarding the stipulation to the prior conviction in the brief. Here, trial counsel presumably stipulated to that, not as a form of impeachment, but as a basis to prove up the UUW charge by a prior felon, and counsel assumedly thought he could disconnect Mr. Scott entirely from the shooting. And so he didn't see the stipulation to the UUW as damaging in any way. He wasn't going to challenge that element of the offense.
Okay, well, that explains it. I just was curious about it. You may
Yes.
go ahead.
And as I mentioned before, here, the fact that the jury heard inculpatory statements that were detailed about the shooting from of the defendant shows that this trial counsel's error certainly prejudiced Mr. Scott because it changed the nature of the case. The jury heard repeatedly. I mean, the jury heard the question asked to Mr. Varikin. The jury saw the video played in court for each of the statements. The jury then later asked for all the videos. It didn't distinguish between evidence that was coming in a substantial nature or in an impeaching nature. After they received those videos, they even went as far to ask for a video that had never been admitted into evidence. I believe this is 155J. The exhibits were entered sequentially alphabetically, and the state never entered that one, so the jury was looking for that. And all this indicates, one, that the jury was clearly looking at Mr. Varikin's statements, and two, that it wasn't using such a keen eye as to which statements had come into evidence for what purposes. And this is further making it difficult for the jury. The jury here, through the limiting instruction, was left on its own to determine what's within Mr. Varikin's personal knowledge, which is a fine legal distinction that can be difficult for some jurists, let alone jurors who don't know the underlying law of whether it's what Mr. Varikin heard or what he knows about the underlying event as set forth in Simpson. And this was further compounded by the fact in rebuttal argument at closing, the state specifically argued that Mr. Varikin told the truth and he should be trusted because he told the police everything that he knew. And it didn't specify that he knew substantive statements versus impeachment statements. So in that way, it encouraged the jury to consider all the statements substantively. And finally, at the post-trial motion of ineffective assistance of counsel, trial counsel noted to the judge that maybe perhaps a bench trial would have been better based on talking to the jury and the fact that they had seen their statements about the evidence that the judge might have seen it a different way. Now, this isn't direct evidence that they considered impermissible evidence, but it certainly is a strong inference that they were considering things not as finely as a judge would have when the evidentiary concerns here were very important, but also very fine, the distinctions between what comes in admissibly and what comes in only as impeachment evidence. Moving to the second issue here, trial counsel was ineffective again when it elicited the testimony of Barbara Mitchell, the defendant's grandmother, in its own case. Ms. Mitchell did testify for the state. It was very brief. She simply mentioned that she lived at a certain location and that Mr. Scott would sometimes visit her. That was the extent of her testimony. It was short, maybe a page. And then in trial counsel's own case, where he hadn't given any notice of an affirmative defense of alibi, hadn't listed Ms. Mitchell as a witness, called Ms. Mitchell, and she immediately gives testimony that directly contradicts a prior statement she gave to police. And this is notably after she had viewed the entire trial. So trial counsel's decision to even call her was an instance of deficient performance because counsel stated on the record at trial after Ms. Mitchell's testimony that he only knew what was in the police report, where Ms. Mitchell stated that she returned home at 10:30 and then her grandson, Mr. Scott, returned shortly thereafter, was angry and demanded that he make her food, which was unusual for him. So knowing these things, there was absolutely no reason to call Ms. Mitchell because she couldn't have provided any testimony that was helpful to the case. And to the extent he believed that she could muster some alibi defense, that would have been severely impinged, one, by her prior inconsistent statement to police, two, by the fact that she'd never told this other story at any other time, and three, by the fact that she had witnessed all of trial. And so not only did her testimony establish where the state had not established that Mr. Scott was in the area of the shooting a few minutes, 20 minutes after it occurred, but it also established a seemingly false alibi, which further tends to prove guilt and creates an inference of guilt. And here the state's main case was all circumstantial evidence. It required the jury to make inferences from the circumstantial evidence, and trial counsel's errors directly supplied something the state had not done, Mr. Scott's location on the day of the shooting, the fact that he could have conceivably been at the shooting. Further, it provided additional inferences regarding the circumstantial evidence regarding a false alibi. And the other errors, I hear the state admits to 6 errors by trial counsel, and all those compiled as well to provide extra inferences to the state's evidence that allowed the jury to point to Mr. Scott. And the biggest issue here is when we're looking at prejudice in the context of ineffective assistance of counsel, we simply don't just take away the improper evidence and say, is it sufficient to convict? We look in light of the improper evidence, the nature of the improper evidence that was involved here. Had trial counsel performed his constitutional duties, would the jury would it returned precisely the same verdict, a unanimous verdict pointing to him? And case law says that in instances when the nature of the evidence is changed by trial counsel's performance, when it goes from purely circumstantial to direct evidence, that is actual prejudice, and the client suffers, and that is precisely what occurred here. So with those arguments, I respectfully request this court to grant a new trial so that Mr. Scott can receive effective assistance of counsel. Thank you, Your Honors.
Thank you, counsel. Then Mr. Nicolosi, is that pronounced correctly?
Perfect. Yes, Your Honor.
Very good. Mr. Nicolosi, you may make your argument at this time on behalf of Appellee.
Thank you. Good morning, Your Honors. May it please the court, Mr. Coltzy. My name is Justin Nicolosi. I represent the state of Illinois in this case. The state asks that this court affirm the defendant's conviction. Just like Mr. Coltzy, I'll keep my arguments pertain to issue 1, whether or not trial counsel was ineffective. If this court has any questions about any of the other issues, I'd be happy to answer those at that time. As I acknowledge in my brief, and certainly can't hide from, there were mistakes that were made in this case, both by trial counsel and the prosecutor. But as I argued in my brief, that the evidence in this case, while circumstantial, very strongly pointed to the defendant's guilt in the murder of David Foley. The first thing we have, of course, are the phone records, which was an issue that defense raised in their brief.
Well, counsel, this, I've never seen a situation like this before where we're dealing with the admissibility of a prior inconsistent statement, and instead of laying the typical foundation, the prosecutor in this case attempts to offer this evidence as a past recollection refreshing recollection, and it's a little bit strange. I've not seen it, and you seem to be arguing that this is something which is permissible.
Well, Your Honor, yes, I conceded in my brief that I think everybody down below analyzed these recordings made by Jacob Verican incorrectly. Defense counsel seemed to think, and I think the prosecutor as well seemed to think, that they were impeaching Jacob Verican. But I think to impeach him, he had to have provided some statement that you were impeaching. And he gets on the stand and he didn't really provide anything of substance, as I, again, concede. I do a lot of conceding in my brief. That does not undercut my
well, I noticed, for instance, the prosecutor said after the trial court explained about why he was letting all of this evidence in and cited Guerrero, that the prosecutor says, and for the portions that he said he overheard the defendant saying it, that would come in for impeachment, not impeachment just itself, not substantively. What's he talking about?
Honestly, Your Honor, I don't know. I don't think that's the proper analysis either. That's why I tried in my brief to get to the bottom of what this evidence was that they presented, that the statements made by Varikin to police. And
So we're clear, by the way, you're not claiming, and I didn't see it in the trial court record, that anything about Varikin's testimony was damaging to the state's case, are you?
no, because again, I think that the analysis was wrong, and I was just using my brief to try to correct what
Well,
happened.
here's my question on the whole idea of refreshing recollection, which is somehow what looks like the prosecutor trial did or tried to do. And it's the fundamental question is this: doesn't the substance that this case the prosecutor is seeking to bring out to the jury by refreshing the witness's recollection have to be admissible? I mean,
Yes,
it's admissible evidence itself, right?
yes.
So it's not as if by trying to refresh the witness's recollection, the prosecutor can somehow cleanse the question and answer from the improprieties that is otherwise present because it's not otherwise admissible. Would you agree with that?
I would. Yeah,
Okay.
I would.
So because, so essentially then the question then becomes, was this, were these prior inconsistent statements, because that's clearly what they were by Verrecken, admissible under section 115-10.1? Does it show that he had personal knowledge of any of this?
I would show that they show that he has personal knowledge of the conversation between defendant and Judea Layman. That's what he's telling the prosecutors about. There's no question that he wasn't at the scene. He didn't see the murder. There's no question about that. I would argue the event we're talking about are the statements that the defendant, party opponent, made to Judea Layman, and that's how they were admissible.
Well, so the defendant supposedly made these incriminating statements to Layman, who then made them to Verrecken?
No, I believe, please correct me if I'm wrong. I believe Verrecken told the police that he was close to defendant and Layman when they were talking about that.
Okay. Well,
That's not that. Sorry.
So essentially, Verrecken is talking about overhearing this conversation in which the defendant is talking about committing this murder. Is that right?
I believe so, but that's not me. I believe I have that correct as it was.
Well, why isn't that essentially the same thing as the Supreme Court in Simpson said was reversible error, because the witness, in this case Verrecken, wasn't present at the killing of Foley and has no personal knowledge of that event?
Well, Your Honor, I think we're not talking about the underlying event, at least from the state's perspective. I'm not talking about the underlying event. I'm talking about the conversation to get the statements admissible, and then the jury would consider whether or not these statements had any weight based on Verrecken's credibility and overall the way he
Wasn't
testified.
that though exactly what the Supreme Court in Simpson said isn't going to be admissible?
I didn't review Simpson before this argument, Your Honor, so I'm not as up to speed on that case as I was probably when I wrote this brief. But my position, the state's position, is that we're talking about the event was not. To that extent, I guess I don't understand Simpson if it's saying that you needed personal knowledge of the event to repeat statements that a defendant made. That doesn't quite comport to me. If we're talking about statements made by a party opponent, I'm under the impression that those would be admissible based on other provisions of evidence, because we're talking about statements that a witness overheard the defendant saying, and that's what these.
By the way, I'm just curious. Excuse me. The The interview with Varenkin occurred in June.
I think so, yes.
The killing of Foley occurred in April. And
Correct.
if I understand correctly, the initial charge against the defendant in this case wasn't until July 2020 by a complaint. And then later in August 26, 20, the case was presented to a grand jury and the defendant was indicted. That's all right?
That sounds right. I'll certainly take your word for that, Your Honor.
So during all this time, Varenkin had been arrested, charged, gave a statement to the police, and was convicted. Took 15 years, as he put it, and he's off in prison, right?
Again, I'll take your word for it, Your Honor. I did not review that.
So here's my question.
Argument.
Why didn't the state call him to testify before the grand jury, given that it's obvious, should have been obvious to everyone, that a guy like Varenkin might testify inconsistently when he's actually called to trial years later, in this case, with what his earlier statement. And the need for personal knowledge, as discussed in Simpson, is a factor of 115-10C2, but there's no need. Personal knowledge isn't a requirement under 115-10C1 if he had testified before a grand jury. Is there any explanation for why that didn't happen here after he gave this police statement?
Your Honor, of course, I wasn't privy to any of the discussions in the prosecutor's office about why they charged him, the defendant, the way they did, and the timing and presenting what they presented to the grand jury. My only guess is, because I can only guess at this point, is that the state believed with the phone records and Coriana Bell's testimony that they had sufficient evidence to go to the grand jury and charge the defendant and establish probable cause for this offense. Because as a hallmark of my brief on issue 1 and issue 2 and throughout, the prejudice prong, of course, is a necessary part of the analysis here when we're talking about Strickland. And I think even not even considering Varenkin's testimony, there's some pretty strong circumstantial evidence that the defendant committed this crime. Of course, he had, there's no real question that the defendant sold drugs to Dave Foley in October of 2019. We also have another gentleman, Robert Jarrett, who sold drugs to Foley in February of 2020. The day of his arrest, he calls the defendant. They try to figure out what happened. They figure out that it was the maintenance man with the raspy voice, which is, of course, Dave Foley. And shortly thereafter, about a month after, Coriana Bell testified that she took defendant and another gentleman to Walmart. They purchased the phone. The defendant grabbed the phone, didn't relinquish it. 18 minutes later, he calls Dave Foley. They're in contact for the next month or so before they set up this transaction. That phone is not used to contact anybody else, only Dave Foley.
Mr.
This phone is.
Could I ask you a question? It relates to the past recollection recorded aspect that you previously discussed and that you addressed in your brief. But Rule 803 identifies the exception. There are 4 prerequisites. It's the 4th one that I want to ask you about. That the witness can vouch for the accuracy of the written or recorded statement. I understand how you addressed that in your brief, but you also saw in the defendant's reply brief the opposing view as to what is meant by that 4th prerequisite. Could you address that?
Well, Your Honor, I believe that what is meant by that is not whether or not Varenkin was telling the truth in what he said. I believe that 4th prong is talking about the accuracy of the statement that Varenkin made, whether or not it was relayed to the trier of fact in the way that the declarant stated it. And in this case, this is recorded. I think because this exception doesn't necessarily apply just for video or audio recordings that would apply to written or other statements. But this one, we have Varikin on video saying what he said. And so I believe it
But
wouldn't be
didn't Varikin say that he didn't recall making the statement in the first place?
Yes, Your Honor, but we have him on video making the statement. That goes to his ultimate credibility. It doesn't change what he said. He said what he said. Whether or not the jury would believe it based on his statements at trial, that's for another discussion. But whether or not the statement was accurately recorded, and I don't think there's any question it was accurately recorded. Again, whether he was, I think he argued he was maybe had too much to drink and was awake for 48 hours, something to that effect. That meant his statements weren't truthful, something to that. Again, that's for the jury, but the state submits that the video recording equipment recorded Varikin saying what he said, and that's what's significant at this point.
So anytime you have a video recorded statement, that fourth prerequisite is basically satisfied. The witness doesn't have to vouch for the accuracy.
I would find it hard pressed, Your Honor, to find a situation where that prong would not be satisfied in a statement that's video recorded. I don't know what the facts would be where that one would not be satisfied in a recorded statement.
Okay, thank you.
Yes, Your Honor.
Counsel, I have a question about this also, about refreshing recollection of a witness, which is the ostensible claim that the prosecutor was using at trial here and the trial judge somehow bought. This is what Professor Graham in Graham's Handbook of Evidence, most recent edition, wrote about it. Two things I want to read you. First is, the process of refreshing recollection must be conducted so as to prevent inadmissible evidence from being suggested to the jury by any means. But isn't that exactly what happened here? If we're talking about evidence of a defendant's statements that are not admissible as a prior inconsistent statement under the Simpson holding because the witness has no personal knowledge of the event the defendant's statements refer to, hasn't the prosecutor, by asking the questions in this case, violated this rule by getting in front of the jury inadmissible evidence under the guise of refreshing recollection?
Your Honor, I understand what you're saying, but the state's position is that video of Varikin making the statements that he did to the detectives was admissible evidence based on the fact that he personally overheard this conversation take place, statements made by the defendant. So with that in mind, that's how I'm arguing that was admissible evidence. And I don't want to. So just to correct you,
go ahead.
You had started that the prosecutor was presenting this evidence as a past recollection recorded. Just to clarify, the prosecutor did not in any way, shape, or form say that that's how they were presenting the evidence. Like I had kind of at the outset of my argument here, I kind of acknowledged that the whole analysis was wrong, that everybody was kind of trying to do impeachment.
He didn't say it, but that's clearly what he was intending to do, wasn't it? And somehow the judge bought this. Didn't he?
That's my argument. I'm just the prosecutor. I'm just trying to, use the facts that are in the record to present my case as best I can. And I believe that's the guise under which the prosecutor was trying to go about it. Defense counsel seemed to agree. Oh yeah, it's impeachment. Again, there were mistakes made in this case. There's no question about it. But I keep going back to the prejudice prong here because we have a phone that the defendant had and was contacting Mr. Foley, only contacting Mr. Foley. The defendant had this phone. This phone was right near the crime scene, along with another phone that could be tied to the defendant. Foley and the defendant clearly had a relationship. There is no question about that. Defendant was on drugs. Defendant was a drug dealer. And this clearly the defendant was mad. Because Robert Jarrett was arrested based on a tip from Foley. Defendant, again, he fired 9 times, hitting Foley 7 times. Clearly, this was not some sort of road rage. This was a man who was very mad at somebody. He was mad because Jarrett got arrested because of Foley. The phone that ties defendant to Foley was right at the crime scene. I understand a lot of mistakes were made in this case.
Let me give you a second quote from Professor Graham that seems to be applicable. This is, again, the process of refreshing recollection. When refreshing recollection is by means of a leading question, counsel may not employ a leading question incorporating the content of the anticipated testimony before the trier of fact if the matter under consideration is of significance in the litigation. For example, when the prosecution seeks to refresh the recollection of a witness it is called regarding a statement bearing directly on the guilt of the defendant, the prosecutor may not use the substance of the statement in her question. Accordingly, a question such as, didn't the defendant tell you on July 4th at the East Bar and Grill that he shot Mary Jane, propounded in open court to refresh recollection is objectionable. Isn't that at best what we have in this case?
It certainly is similar, Your Honor, but I have to keep reminding this court there's 2 prongs to a Strickland analysis. Again, I understand mistakes were made. That doesn't detract from the proper evidence that was presented of defendant's guilt in the shooting of Dave Foley. And as I just—
By the way, you cite the Jackson case as being some authority for prior recollection refreshed, but in Jackson, the evidence that the prosecutor used had already been testified to in open court, hadn't it?
Yes, Your Honor. Yes.
So there's no question about it being improper or prejudicial. The witness is having his recollection refreshed with testimony jury's already heard.
I understand, Your Honor. I'm just trying to make the best case that I can, given the poor performance all around by the court and the prosecutor.
Counsel, I appreciate it. You're the guy following the elephants in the parade in this case. You're not the trial lawyer, so I appreciate you're doing your best you can on a difficult record.
Yeah, I understand, Your Honor. Thank you. So with that, I would again try to nudge this court as best I can towards considering the prejudice prong of a Strickland analysis and the proper evidence that was presented in this case that the defendant killed Dave Foley. There is that evidence. It is proper. It was strong, albeit circumstantial, still strong. The state submits that this court should affirm the defendant's conviction. If there are any other questions, I'd be happy to answer them.
Okay, thank you, counsel. Mr. Coltsey, any rebuttal argument?
Just briefly, Your Honor, as mentioned by this court, counsel's arguments regarding the personal knowledge requirement would be requesting this court to essentially overturn the holding and the analysis in Simpson, which specifically states that the knowledge is of the underlying event and not what they overheard from a third person. And then regarding recorded recollection or past recollection recorded, this court is correct that 2 of the elements were clearly not met here, the foundational elements. One foundational element is that the statement was made at a time when the witness could recall it, and clearly here Mr. Vreekin testified that he had no memory of any of the conversation because he was drunk on drugs and hadn't slept. Furthermore, as the court held or examined in Jackson, the state cited by the state here is it doesn't just simply presume that if the statement was recorded, that is in fact accurate. It's not the specific recording, it's the contents of the recording or instrument that need to be accurate. And with that, I will rest my arguments.
Thank you, counsel. And again, I apologize to counsel for the delay in getting started. As I say, it was my fault. Appreciate your arguments and your responses to the question we had. The court will take this matter under advisement, issue a decision in due course, and will stand in recess at this time.
Thank you.